Hi, welcome back to Melone Hatley's podcast. I now pronounce you divorced. I am your host, Dan Cuneo. And again, we're joined with today William Koontz out of our Columbia, South Carolina office. William, thanks again for taking time to join us.
Good morning. Glad to be here.
Yeah, last time we had you on the podcast, we were talking about parenting plans and as everybody was getting through the holidays and starting the new year. And you mentioned a lot of topics that we didn't get an opportunity to speak about, but that we were receiving questions on. And I wanted to kind of dive into some of those today on those issues. And one of the ones that you talked about in the last podcast was social media in the context of, if you're sending a text message or you're sending an email. I want to kind of dig into that and how important social media is and what to do, what not to do, and how it really plays a role in a judge's decision. So I know it's a very open-ended question. And so I'll start with, everyone is familiar, or at least heard of Facebook or Twitter or Instagram. What are some of the cautions you have if you're we'll say if you're in litigation, you're going through a divorce or a separation, what to post, what not to post, and I'll even throw in a little bonus too, what not to comment on or to like as well, because that could affect cases as you're going through the litigation.
Well, what I'll start off with is when it comes to social media, don't hide anything from your lawyer. If you're in litigation, um, the you can't change the messages you've sent. You can't change what you've posted online. So it's important to, be fully transparent. Here's the things that I've said that, you need to be aware of on the front end. It's always better to let your lawyers know about, the bad just as much as it is the good. The second thing is that just like any other form of correspondence, while you're in litigation, the court is looking at everything you say and do under a microscope. And that includes not just the posts you make on Facebook with a picture of your kid. It includes your direct messages on Snapchat. It includes your account that you may have on an adult website. These are all forms of social media that the court can consider and look at. And so if you're talking to someone that you may have a romantic interest with on Facebook, that's going to potentially come in under discovery. And so what you should do, especially these days, be mindful about the different types of accounts and the different types of social media websites that you're on. It's always a good course of action to say nothing at all. What I sometimes, and this is a simple example, I sometimes tell clients is, well, you're in litigation, I want you to be a sponge. A sponge does not let anything out. It just absorbs material in. And that's a really good starting point, especially with social media where, again, the second you say something, that is permanently someplace online and will be brought back up later down the road.
Right. And it's such good advice because sometimes the emotions can get the best of our clients because they're going through a pretty heated debate or there's an awful experience. And I see a lot of individuals just go out on social media and that's their way of just relieving the tension or the stress or coping with something. And it can backfire, especially if you're posting or commenting on things that you shouldn't be commenting on or posting, such as saying bad things about your significant other, your spouse, or their family or their friends. What are your thoughts? Because I've had this when I was litigating to where it benefited my client because we were able to get a hold of other media posts that had alcohol in the backgrounds or maybe it's certain events that they shouldn't be at with the kids. How important or what is the effect that has in South Carolina if you come across media posts or pictures to where maybe the other side is out where they shouldn't be or there's something in the background that you might be able to use to your benefit?
Yeah, well, again, the best place to start is with a conversation with your lawyer. Here's the information that I have about what's going on. Because if that is, well, I'll give you an example from a case that I've had. You could see the crib and the child in the background on OnlyFans material. Okay, that's the type of thing that a court in South Carolina is incredibly concerned about because now it's showing not only poor judgment on the parents' part, but it's also showing an exposure of the child to potentially either illicit or unhealthy types of activities. If that's alcohol, now you potentially have a parent who is, consuming alcohol to a unhealthy or unsafe degree while they're taking care of, of their kid. And so if you have a child who, falls and hurts themselves, the parent's too intoxicated to be able to take them to, the hospital or to the doctor's care. And so that's the type of material that, will illustrate, the a parental unfitness, as it's called in South Carolina, and is really important to be able to demonstrate to your lawyer. They'll be able to send out discovery requests or subpoena, provide that information to the guardian ad litem. But what you should not do is, say, for example, respond to that picture on social media. That's the type of information we want you to send to your lawyer. Okay. Because there's not going to be anything that you're going to be able to achieve by proving yourself or by having an argument on social media about this. That's an argument that your lawyer needs to make in court.
Right. And I know a lot of times clients come in and they'll have an account that they shouldn't have, or they posted something they shouldn't have, and they just say, well, I'll just delete my whole Facebook account or my whole Instagram account. What do you advise clients when they come in, they just want to remove everything and delete their social media?
Well, first and foremost, it's never really deleting your social media information. All that you're doing in the United States is requesting that your account credentials no longer function to access the data. But Meta, Alphabet in Google's case, Apple, they all still retain your subscriber information. That includes your pictures, your posts, your direct messages, even your disappearing messages on Snapchat are still maintained by Snapchat. And so even though you may make it a little bit more difficult to access the material, it's still out there. And so now you have a problem where the court sees that you're trying to take a lot of energy to keep this information out of the court, and it's still going to come in. So my advice is always, it's better to acknowledge it on the front end than it is to try to sweep it under the rug on the back end.
Where does spoliation of evidence come into play? We've had some clients come in and they say, well, I've heard this. I don't know if it's true. Can I get in trouble if I remove my social media accounts?
So spoliation of evidence occurs when you've been put on notice of some variety. Let's say you've been sued for modification of custody. There's a divorce lawsuit going on, something of that nature. Mm-hmm. And you destroy or delete some bit of necessary information. So let's say, for example, your text messages to your girlfriend while you've been married, or your boyfriend while you've been married. If you delete those, the court can draw what's called a negative inference. And so the court will say, essentially, that you had this information, and the only reason you would have destroyed it is because the information was incriminating against you. And so therefore, the court's going to assume that, whatever those messages were likely related to, your affair or whatever. And so now you have not only the fact that the court's drawing a negative inference against you, but the court is still concluding that, in this case, you had an affair or something of that nature. So now you've been hit by two things, instead of just addressing it on the front end and saying, look, I messed up. These are the messages, or this is what transpired.
Mm-hmm. How, you raised a lot of interesting points when it comes to social media. How discoverable is social media, and what are the steps to get access to some of these platforms that you were mentioning? We talked about Twitter, we talked about Instagram, we talked about Facebook, we talked about Snapchat. Is that easy to get? And then I guess the second part of the question really is, if the account is inactive or removed in some way, form, or fashion, how hard is it to get access to that?
The great lawyer answer, once again, it depends. So There's a couple of different approaches here. The easiest is to just request that material in what's called formal discovery. So that's where you're asking, you're at the other side, your wife or your husband, for a copy of their social media information. And you can go online and access a copy of this yourself. Facebook calls it their archive, and so you could download an archive of absolutely everything from your Facebook. The second step, if that doesn't function, is that you can subpoena these companies, and those have a hit or miss rate. Most companies do not operate their headquarters in South Carolina, especially social media companies. So that makes it a bit more difficult to acquire the information. And the court can also always issue an order compelling production of these documents. So there are ways to obtain even deleted accounts. But at the same time, there are also all sorts of new social media websites. Blue Sky, for example, following up after X, formerly Twitter, it uses a different structure of account data, and so it's a little bit different to access Blue Sky messages than it is Twitter messages, which is why it's very important to talk to your lawyer early on in the case and identify, what behavioral patterns you use and your spouse uses, so that you can identify, okay, we need to ask for Facebook, or we need to ask for OnlyFans or Grindr or Blue Sky, because each of those, is going to require a slightly different approach. And excuse me, getting the time in early in the case means that you can get those responses sooner, and you can do something with those responses sooner, whether that's proving your case in a hearing, or demonstrating that parental unfitness so that you can get more custody and visitation time with your child.
As you were talking, I'm thinking this all really comes back to a comment that you made on the prior podcast, which is just be honest with your attorney. How important is that for a client to come in and just make sure that they're completely honest and transparent with you, the good, the bad, and the ugly? And I say that because clients are coming at their worst time, and they sometimes may be ashamed or embarrassed of some of that actions that they have taken, or things they said, or things that they know. But as lawyers, we need to know everything, and it's really our job to kind of parse out what we think is beneficial and what we think is a risk, so then we can act appropriately. How do you handle those types of situations with clients?
So the first thing I will always tell the client is that during especially in those initial meetings, they will never remember every question to ask me. They will never remember everything that they wanted to tell me. It's human nature. And so I tell them, keep that diary, keep that journal, keep a little app on your phone. When a question comes to your head, or when you think, I should have told William this, okay? And it happens like 3 a.m. because that's how the brain works. Jot it down, okay? Because that's the type of information your lawyer needs to be aware of and needs to be able to act on. The second is, especially early on in your relationship with your lawyer, you have to build trust and confidence in the process. And that means divulging everything. It's just like you said, the good, the bad, and the ugly. You can't change any of it, okay? It's already been written in stone. But I can't help you with the ugly stuff if I don't know that it's out there. Mm-hmm. And I can almost guarantee you that it's going to be twice as bad to deal with down the road than it is to deal with it now. And the third thing that I will tell people, especially when you're dealing with divorce in particular, is that this is a process of grief. And as a process of grief, as you're losing that identity of a family, of a marriage, of what you're going to be, doing 5 years, 10 years, 15 years down the road, there's a lot of emotion in that. And it's like what you said, there's levels of shame, that question of how responsible for this am I versus, my spouse, and there's embarrassment. I do not judge any of my clients who come in the door. What I do is I want to figure out what I can do to help them. And that means understanding the ugly sides and the good sides.
Mhm.
So tell me everything. It won't surprise me. Promise.
Well said. And I try to walk clients through that. We need to know this. So the worst thing, at least in my experience, is being surprised by the other side or the judge asking a question that I don't know the answer to. And then it comes out that it's as a negative inference, as you would say, or negative effect on my client. In the jurisdiction that you practice in, is it hard to rehabilitate a client? They come in and they have these bad, ugly situations or things that they've done. As long as you know, is there a way that you can be proactive and take a different approach and rehabilitate the client so the court doesn't necessarily give that much of a negative inference or impact to the verdict or to the ruling?
Yeah, absolutely. The you know the difficulty is how long that battle has to be to rehabilitate so that we can win the war, and that just depends upon how much we have to rehabilitate. There's very few situations in South Carolina um, where custody and visitation are going to be entirely removed from a parent, and in order to get to that point, um, it's incredibly difficult to reach that point of termination of parental rights. So you can rehabilitate anything, but you have to have a willingness to do so, and that may mean you know involving experts like a psychological expert to weigh in and determine, are there any mental health issues that may be making these issues more difficult to address. It may be getting the involvement um, of a parental support therapist to provide that parent with better coping skills or better coping mechanisms. It may simply be as basic as just giving some time. If you have a parent who is recovering from a substance use disorder, for example, that's something that it just takes time for the court and for the other side to see a demonstrated compliance towards recovery. And that's not going to happen overnight, but it will happen. Um, I tell parents, we never look for perfection, ever. We, and you can't find it in a parent. What we look for is accountability to make sure that when you do mess up, you're going to fix that going forward in the future, um, and accountability for the consequences of those actions. But that doesn't mean it's forever at all.
How much weight does the court give if you have a client that comes in and, to what you mentioned previously, accountability? They own what they did, whether it's an abuse, substance, physical, something like that, but they own it and they want to improve. Does that weigh in the court's decision to maybe allocate parental time or sharing of responsibilities? And if so, is it something that you have to come back to continue to modify till you get what you want? Or is it just based on the circumstance and how far along that the potential client is in trying to really take ownership and rehabilitate themselves?
Another great lawyer answer. It depends. All of the above. What the courts, primarily going to be looking at is, the depending upon the severity of, what occurred, um, is going to change, what sort of safety and mitigating factors the court's going to put in place to ensure, compliance on the part of the parent. So if you're looking at something like a substance use disorder, uh, that is going to be, there's less risk there for the court to have to require for monitoring it than if you have a parent who's engaged in physical abuse in the past, for example.
Mm-hmm.
And so the court may have, for someone who's suffered from substance use disorders, a ongoing requirement that once every quarter, the other parent can request a 24-hour drug alcohol test. That's the sort of thing that is very easy to satisfy, to show that ongoing commitment to improving yourself as a parent. So you wouldn't have to come back in front of court or anything of that nature. But if there's an abuse profile involved, then that may require the court to have some type of ongoing oversight to ensure that compliance. So it depends. Um, Again, the important thing is talking to your lawyer early on so that when you are trying to show that improvement over time, you're doing it in a way that the court's going to understand and is going to, interpret as this parent is committed to getting better for the sake of their son or the sake of their daughter, so that you can get through that battle so you can win the war.
That's great advice. It really is all about winning the war, which is what is your goal and how can we get there? Don't focus on every battle, focus on the bigger picture, which is the war.
Yep.
Well, I want to thank you for taking time to speak with us again today for this podcast. I now pronounce you divorced. For those of you who are out there and you're thinking about going through a divorce or a separation or a modification, or you currently are going through one, give us a call at Melone Hatley. Let us speak with you so we can talk to you about any risk or, as William was saying, how can we set you up best to potentially win this war? I'm your host, Dan Cuneo, and this is Melone Hatley's podcast, I Now Pronounce You Divorced. Please don't forget to like and subscribe and send us questions. We like to try to answer them on future podcasts. Thank you.
Thank you, Dan.
Thank you for tuning in to our podcast. If you found this episode helpful and you want more informational content, please be sure to subscribe and join us on all major social media platforms, including YouTube. Stay connected for more exciting updates and tips.